Well, good morning, everybody. My name is Gary Kajowski, and we have the pleasure this afternoon to have Director Marcia Waters, on behalf of the Division of Real Estate, talk to you about important real estate issues for consumers. And today's installment is going to cover some of the common real estate documents used in a purchase sale transaction. We also surveyed questions in advance from the attendees, and you responded. And if we have additional time after the presentation, we will go ahead and cover those for you, but you can put questions in the chat box for us. We'll also record today's presentation, so you have the opportunity to review it later. So at this time, I'm going to turn it over to Director Waters.
So good afternoon. We're going to go over a few of the contracts that we regularly get inquiries from consumers about, and also we hear complaints about from consumers as well, and just kind of walk you through those different documents. We're not providing legal advice, but we did want to touch on some of the different points that come up for consumers that I don't think most people are aware of. So before we launch into the discussion of the contracts, we're going to go over 2 contract documents and 1 disclosure document. So we'll be covering the listing contract, the seller's property disclosure, and the contract to buy and sell today. But before I start going into those, just to kind of give you guys an explanation, the Real Estate Commission promulgates contract forms and disclosure forms for licensed real estate brokers to use when they are performing their license duties with consumers. So these forms are really geared for the brokers to be using. They are available on our website if you want to pull one off and use it. But it's kind of like, from the non-educated consumer perspective, this may not be the best document for you to use if you're going to do your own transaction. You might be better off finding a contract elsewhere. You may want to consult with an attorney. They used to have basic real estate contracts available at office supply stores. I don't know if they have those there anymore, but these forms are geared for the real estate brokers to use. And the important thing to remember when we start going through the contract documents is those are legally binding contracts. So if suddenly you want out of them, there could be legal implications associated with that, and chances are, if you're trying to get out of a contract, you're going to have to contact an attorney. With our Real Estate Commission approved forms, those are updated periodically. We have a adjunct forms committee that reviews the contracts and makes revisions on an annual basis, but our forms don't change. Each form is not scheduled to change for 3 years unless certain circumstances happen. But typically, we don't change the forms unless we hear that, you know, there's something that's not working right. There may have been cases that were litigated that we discovered that the language ought to be modified in one of our commission approved documents, or, you know, there's a law change. And some of what you will see, particularly in the contract to buy and sell, some of the language in there is specifically the result of legislative changes that come about with laws being passed. So we'll start off with the listing contract. We have 4 basic listing contracts. We've got the exclusive right to buy, and that is what a broker is going to use when they're representing somebody who wishes to buy real property. You've got the exclusive right to sell contract, and that's what a broker will use when they are going to represent somebody in the sale of their property. There's the exclusive tenant, and that's when the broker is representing the tenant in a transaction. And then there's the exclusive right to lease, and that is the contract that the real estate broker will use when they are going to work with a property owner to lease their property. And these listing contracts are essentially binding contracts that the consumer is basically engaging the real estate broker to perform licensed real estate duties. And kind of a high-level definition of a licensed real estate duty is basically when the real estate broker is bringing 2 parties together and they're negotiating the terms of a real estate transaction. Advertising the property of another person for sale or lease or exchange also requires a real estate broker's license. But for the most part, typically when we think of license duties, we're thinking of the brokers bringing 2 parties together and negotiating. So the listing contract is going to address a variety of things, and I will get to some of these topics that are on your screen right now. But one of the things that I want to touch on before we go into some of these sections is it starts off with, when you engage a real estate broker, you may have a broker that is off on their own, or you may have a broker that works in a brokerage that has a bunch of other real estate brokers that work for it. If you're only dealing with the one-man shop real estate broker, you're only going to be interacting with that licensed professional. What you need to keep in mind, though, is if you are hiring a real estate broker to represent you, and that broker works for a multi-person firm, just because you engage that one broker doesn't mean everybody in that firm works for you. That's not how it works. You have a designated broker, and that is the person that is named on your listing agreement. You might have a couple that are named on your listing agreement. A lot of brokers work in teams. So you may have a couple different brokers that you're working with as a result of them being a team. But just bear in mind, if you contract with a real estate broker that works for a multi-person firm, you are not working with every broker in that firm unless they've got kind of an alternative business model, but that should be addressed in your listing contract. The other thing to keep in mind is it's not uncommon for real estate brokers to change firms, and they may do so regularly. So if I sign up with a real estate broker that works for ABC Real Estate Brokerage, and my broker decides that they're going to go work for 123 Real Estate Brokerage, ABC Real Estate Brokerage owns my listing contract. So my listing contract is not going to transfer with that broker unless that original brokerage firm releases it for me to go with that broker. And the employing broker at the brokerage firm, who is the head of the brokers, can also switch out my broker if there's an issue that arises or if my broker leaves. So they can assign somebody else to my contract. So just a couple things to know if you deal with a multi-person firm. So one of the other parts about the listing agreement that you need to be aware of, particularly from the buyer side, is the listing agreement is going to ask you basically what the broker is representing you for. And if I want to buy a house in the state of Colorado, the property description can be as basic as Marcia wants to find a residence in the state of Colorado, or it could be really specific to, I'm looking for a residence in Denver, Colorado. So it can be very broad or very specific, and that's something that you need to be aware of. You may want to refine that language so that it's not overly broad in case if you're going to engage in multiple types of real estate transactions and maybe you don't want that broker to represent you in all of those. With the exclusive right to sell and the exclusive right to lease listing agreements, it's going to ask for the legal description of the property. It's really important that you make sure that the legal description is the actual description from the vesting deed, not the abbreviated version from the assessor's office. That's really important. And that's something that you need to also make sure of when you're dealing with the contract to buy and sell, which we'll go over last. The next item has to do with the listing period, and I think that's on the next screen, Gary. The listing period, this is going to be when your contract with the real estate broker begins and ends. Typically, the Real Estate Commission doesn't like to see listing agreements for longer than a year. But this is another point of negotiation between the consumer and the broker. If you're not really familiar with the broker or you're not sure of their abilities, you may not want to have a very long listing period just because you will be stuck with that broker for that period of time. And if you decide that this is not a good fit for you and you're trapped in a 9-month listing agreement, that may be 9 months of torture for you. So you may want to have a shorter listing period. Conversely, if you are well acquainted with the broker, you don't have any concerns, and also considering kind of what is going on in the market and also, the details of your property, you may opt for a longer listing agreement, and that is something, ultimately for you to decide. And then what happens is as you reach the end of that agreement, if your property still hasn't sold or you haven't found a property to purchase and you want to continue working with that broker, we have documents that allow the real estate broker to do an extension of that listing agreement, and those are done in writing. their agreements to amend, extend, but we're not going to go over those today. So the next part about the listing contract that you need to be aware of has to do with the brokerage relationship. And this is how the broker is going to represent you. And there's one of two ways they can represent you. They can be your single agent, which is your advocate, or they can be your transaction broker, which they're basically a facilitator at that point. In addition to the brokerage relationship, the listing contract is going to go through the brokerage duties. And there's uniform duties that the real estate brokers have to provide, whether they're your single agent or your transaction broker. And basically, just to kind of gloss over those a little bit, those involve performing the terms of any written or oral agreement that they have with you as the client, presenting all offers in a timely manner, advising the client on the transaction and advising the client to seek expert advice beyond the broker's expertise, accounting for all money and property received in a timely manner, keeping the client informed, maintaining confidentiality regarding what you're willing to pay as a buyer or what you're willing to accept as payment as a seller. The motivating factors for your reason to buy or sell, those are confidential as well, and the broker has to keep them as such. And then if they're your single agent, they owe you additional duties, such as having the utmost good faith, loyalty, and fidelity to you, seeking a price and terms that are set forth in the contract, and then counseling their client as to the material benefits or risks of a transaction that they actually know about. So those are the brokerage duties that they're going to have to perform. You can go into additional duties that you guys agree on, and we'll cover that a little later in this contract. Those fall under additional provisions. There is something that you need to be aware of that a broker does have to disclose, and this is required by law. So they have to disclose all known adverse material facts about the property or the buyer. So an example is if the property that they've listed to sell has a crumbling foundation and they're aware of it, regardless of what the seller tells them, they have to disclose that. The seller can't tell them, hey, I don't want you to disclose it. It doesn't matter. The broker has to disclose it. Now, on the buyer side, if I'm representing a buyer and the buyer tells me, I have really bad credit, I can't qualify for a loan, and I have no money, but I want to go out and put offers out on houses, then their financial situation is something that I'm going to have to disclose that my buyer cannot get a loan to consummate this transaction. That would be an adverse material fact on the buying side. So after you get through the brokerage duties, then the listing contract discusses compensation. And this is something that I think a lot of consumers don't understand. Real estate commissions are negotiable. And this is a discussion that you need to have. Not all brokers are paid the same way. Some brokers base their commission on a percentage of the sales price. Some real estate brokers take a flat fee. Some will take an hourly fee. Some may collect a retainer and charge you an hourly fee. Regardless of what the pay structure is, this is negotiable, and this is a conversation that you need to have. Because what we've been hearing about lately in the past couple years, particularly with the type of market that we've had, is we have real estate consumers that enter into listing contracts with brokers. The brokers perform all of the duties that they're required to perform per the contract. And then when closing comes, the buyer or the seller decides, I'm not going to pay this commission. I don't think they should deserve that amount of money. And so they tell the entity that's handling the closing not to pay the broker commission. And then at that point, you're probably going to find yourself on the other end of a lawsuit because the broker can sue you at that point because this is a legally binding contract and you did agree to pay them. So definitely make sure that you're having a conversation with your broker about their commission and how it is structured, what you're going to end up paying. The other thing that you need to know if you are on the buying side is there's 3 options about how you pay. They're called success fees on the buyer side, but it's the real estate commission. It's just semantics. The first option is the listing brokerage or the seller may pay your buyer's agent or your buyer's transaction broker their commission, but you're obligated to pay as the buyer. That's one option. The second one is you, as the buyer, you're just going to flat out pay your broker's commission. The third option is that you can seek payment of your buyer's broker's listing or compensation from the listing broker or from the seller, and that you as the buyer is not obligated to pay. The reason that we're bringing this up is sometimes what we've seen is if you've got a listing and maybe they have listed with a broker that charges a flat fee, and the cooperating commission that that listing agent is going to pay a buyer's broker is not equivalent to what the buyer and their broker have negotiated as a commission, and they've checked that first box saying that regardless, they're going to seek payment from the listing company, but regardless, the buyer is going to be responsible. So if the flat fee that the listing broker is offering to pay the buyer's broker as a cooperating commission is less than what you've agreed to pay your broker on the buying side, you are responsible for making up that difference. Also, if you were going to buy a for sale by owner property and you've checked that first box or the second box as well, you are paying for your broker's commission. Chances are for sale by owner, they're for sale by owners for a reason. They typically don't want to pay a broker's commission, but you could end up as a buyer having to pay your broker's commission. So just be really careful about when you're discussing commissions, who you're going to be seeking payment from if you are a buyer, and be aware of that. Some of the other things that you need to be aware of that some brokers will charge is they will charge early termination fees. If you want to get out of the contract before your expiration date, you'll have to pay a fee. Those types of fees have to be memorialized and agreed upon in writing in this listing contract. Sometimes they'll charge marketing costs. Again, those need to be in writing. You have to agree to them, and you would find them in this contract, probably under additional provisions. So they're negotiable. Be careful about what you negotiate, because if they perform all of their terms and you don't pay it, they can take you to court to get their commission paid to them. So once you discuss commissions, then we move into the holdover period. The holdover period basically is the period after your real estate contract has expired and you haven't purchased something or your property hasn't sold. There's a negotiated duration of time that you negotiate with the broker about, if in 15 days after my listing agreement expires with my broker, and say like I'm the seller, so somebody had come to see the property, there were some communications back and forth with my broker as far as interest in the property. If that person comes back 15 days after the holdover period and the broker has kind of given me this list in writing of potential buyers that will come in, that came in during when the property was listed for sale, if they come in during this holdover period and they're on the list that the broker has given me, then the broker is entitled to a commission. This is another negotiable point of the contract. You could have a 0-day listing or a holdover period. Sometimes you see a 90-day holdover period. It's negotiable, and just be very aware of what you're getting yourself into. And the holdover period, basically, like I said, the broker's got to provide you with either the name, if it's on the listing side where they were listing your property for sale or lease, the name of a potential buyer or potential tenant. They've got to provide you with that. Or if you were a buyer and they were out showing you properties, they're going to have to provide you with the property address in writing that they showed you while you had that active listing agreement in order for them to get compensation in the holdover period. Then that takes us into the marketing aspect of and the marketing aspect applies to when you have a property listed for sale or for lease. So your broker is going to discuss with you whether you want it in a multiple listing service, if you want it advertised on the internet, do you want to have open houses, do you want to do virtual tours? Again, these are all points of the contract that are negotiable. If you don't want to have your property listed in the multiple listing service, you don't have to. This section also discusses property access, though, and this is a complaint that we get quite a bit because we have a lot of brokers that have provided access to people to go view properties when they shouldn't have. So the Real Estate Commission has a rule that says any broker who is not the listing broker cannot share access information to the property with any third party without prior authorization from the listing broker. So if you're under contract and your buyer schedules to have the appraisal done, the buyer's broker can't just give out the lockbox information for the appraiser to go do their job as far as appraising the property and the inspection. They're going to have to get authorization from the listing broker representing the seller to give out that information. Otherwise, the listing broker is going to have to make other arrangements to enable the appraiser to complete their job. And this isn't just for appraisers, it also covers property inspectors and unlicensed assistants. And that's another conversation that the broker should be having with you is a lot of times brokers will have unlicensed assistants that they may utilize to go out and do showings. You as a seller have a right to say, no, I don't want an unlicensed assistant showing my property. So that's a conversation to have with your broker. You can put other limitations on showings as far as access to your property is concerned. You could require that showings can only be done by your listing broker. You're going to need to have a conversation with your listing broker about that because they may just not have the time to be able to manage that type of a requirement. You can set limitations on there's no showings on Mondays, there's no showings after 6 p.m. Just bear in mind that the more restrictions you place on how people can access your property to view it could significantly reduce your potential pool of buyers. The contract also covers obligations that you as a consumer have to your broker. Specifically 2 issues that you need to be aware of. So all negotiations related to the real estate transaction will be conducted through your broker. That's what the contracts say. And the second part is that any communication related to the real estate transaction will be referred to the broker. So if you have somebody that's reaching out to you, sending you offers, you need to loop your broker in and they need to be part of that discussion. That is what the listing contracts are requiring. The other part that a lot of people complain to us about and don't seem to be very clear on has to do with the price terms and also the earnest money deposit. And this is specific to the exclusive right to sell contract. The sales price of the property is not determined by the broker. That is determined by the seller. Typically, they're going to give you a comparative market analysis so you can kind of look at the market and see where you need to price your property at. But ultimately, you pick the purchase or the sales price as the seller. They're going to discuss different terms with you, such as what type of financing will be acceptable to you as far as what the buyer brings in. Certain types of loans require the seller to pay some fees on them. You may decide that you don't want to pay those fees, so you don't want to allow those loans. It just reduces your buyer's pool. And then the earnest money deposit, that's something that you need to decide as far as what are you going to require as the earnest money deposit when you get an offer in. And that's something that you can get guidance from your real estate broker about as well. The listing contract's also going to go into inclusions and exclusions. So if there is something that when you sell your property you plan on taking with you, like grandma's prized rose bushes, you need to make sure that that is listed as an exclusion in your contract, particularly in the contract to buy and sell. Because if it's missed in the contract to buy and sell, chances are you're not going to get to take it with you. And then there's language in there about the termination of the contract. The contract terminates either when the listing expires or the transaction is completed, whichever happens first. If you decide that you do not like working with this real estate broker, or maybe the real estate broker decides that they don't like working with you, you can ask to be released from the listing contract, it's got to be a mutual release. And if the other side agrees to release you, you need to get that in writing just to kind of cover your end. Otherwise, if they refuse to release you from the contract, if you call us, that's when we're going to tell you that you need to contact an attorney, because you've got a legally binding contract, and the Real Estate Commission does not interfere with those. So you'll have to seek legal assistance. And then the last part of the listing contract that we want to go through has to do with additional provisions. And this is really kind of a blank section at the end of the contract to address any additional terms that aren't covered in the general language of the listing contracts. And that may be additional duties that the real estate broker agrees to perform for you. You know, maybe they're going to arrange for lawn maintenance, supervise some repairs, whatever they may agree to do. It's got to be in writing, and it needs to be in additional provisions. And that's pretty much your listing contract. So why don't we move on to questions?
Yes, and Director Waters, I have 3 questions. Number 1, are there any additional disclosures that one should know about before entering into an exclusive agent agreement?
So before you start giving confidential information to a real estate broker, they've got to disclose the different types of brokerage relationships available for you. Because basically, if you're not going to engage them, you shouldn't be giving them confidential information. But aside from that, there really aren't any additional disclosures. There's a whole lot of disclosures that come into play once you go under contract. But the big ones kind of starting out the gate are the brokerage relationship disclosures. And then we're going to go over the next type of big disclosure that you're going to have to deal with, which is the seller's property disclosure.
Okay. So question number 2, can a broker just put my house in the MLS to list it and do nothing else?
So Colorado license law does not allow a real estate broker to do that. I went over the brokerage duties. They have to perform all of those brokerage duties. They cannot just contract with you to put it in the MLS. And this is why I brought up at the beginning that if a broker is going to advertise your property for sale or lease, that requires a license. And by virtue of that requiring the license, they either have to act as your single agent or your transaction broker. So this concept of I'm just going to pay a real estate broker $500 to put my property in the MLS and advertise it in there, that's a violation of our license law for a real estate broker to do that. And the Real Estate Commission does discipline brokers' licenses for that behavior.
Okay. And here's a really broad question for you. How difficult is it to list and sell my home on my own?
So real estate transactions in general are really complex just because of all of the different legal requirements and also the documents that you're dealing with. I think it's really going to depend on how comfortable you feel navigating one of these transactions. I've heard a lot of people say that they actually just go to real estate school to be able to manage their own transactions without engaging a real estate broker. You always have the ability to reach out to an attorney as well. An attorney can't function as a real estate broker, but they definitely, by virtue of their license, can deal with the contract side of things. But I think as we walk through the contract to buy and sell, that may be kind of a rhetorical question when we start going through some of the legal disclosures that you have to deal with. You may decide after you hear about the contract to buy and sell that maybe you don't want to do this on your own.
Okay.
But there are other professionals out there to help you.
Great. Well, we are set to move on to the next part, and that's the seller property disclosure.
So the seller's property disclosure is a form that the seller completes, not the real estate broker. And if a seller decides that they're not going to complete this property disclosure, there's actually language in the contract to buy and sell about it being completed and provided. So, and there's a lot of legitimate reasons why a seller wouldn't want to complete this disclosure. If you've got a bank-owned property, the bank's probably not going to know anything about the condition of the property, so they may not want to complete one of these. If you've acquired a property because, you know, your long lost aunt has passed away and she willed the property to you, again, You may not know anything about that property, so completing the seller's property disclosure may be a moot point. You just need to make sure that if you're not going to complete it, that the language regarding it is stricken from the contract to buy and sell. With that said, though, if you don't complete a seller's property disclosure, if you are aware of adverse material conditions with the property, you still have a legal obligation to disclose those. And the disclosure that we deal with the seller's property disclosure is your current actual knowledge. It's not what the seller should have known. And again, so if you disclose adverse material facts to your real estate broker, they are required by law to disclose them regardless. So just bear that in mind, that if you tell them, listen, we had floods in northern Colorado about 15 years ago. If the property was flooded back then, that's something that the broker is then going to have to disclose. When, as a seller, you are going through this document, you need to read it very carefully because the language throughout the document changes. So depending on what portion of the document you're dealing with, the questions may be, has this condition ever existed? So like structural problems or a roof leak, versus other portions that say, is this a condition that's now existing? So like an issue with one of the appliances or an issue with the sewer. In going through the document, it's a comprehensive document. It covers a bunch of different components associated with the property itself. It's also going to provide just some basic informational data about the property, such as what's the source of water? Are you on city water? Are you on cistern? The type of heat, is it forced air, electric? So those are portions that you complete as well. There's other portions that also address legal issues, such as, is there a zoning violation? Are there violations on the property associated with an HOA, building code violations? Are there other legal actions pending? It addresses access and parking. It covers environmental conditions, and environmental conditions can include whether there were pets kept in the residence, is there asbestos, is there radon? Colorado is known for expansive soils. It asks about that. Did you smoke in the property? Is it located in a floodplain? And it also has questions about common interest communities. There is an advisory at the end of this document to the buyer. And really that advisory speaks to, it falls on the buyer to do their due diligence. The seller's required to report what they know about the property. But really the buyer needs to exercise their due diligence. And typically what that means is the buyer should be having an inspection done of the property. And you may need to go above and beyond just your typical property inspector. You may have to engage experts from various different areas, depending on just different features of the property. So if you have concerns about the foundation, you may need to engage a structural engineer. Colorado is known for having radon in its soils. If that is a concern for a buyer, they're probably going to want to reach out and have somebody do radon testing on the property. If the property was contaminated due to an illegal drug laboratory, a meth lab, that's something where you'd look at engaging an industrial hygienist. So there's different experts to deal with different issues. You may want to have the roof certified. There's just a whole bunch of different things that the buyer needs to consider, but they definitely need to do their due diligence. We get a lot of complaints in where the buyer has, decided to save $300 and not get a home inspection done, or they let somebody who's unqualified do it, like their brother. They close on the property, and then after they've moved in, they discover a whole list of different issues that probably would have been identified if they would have had a professional inspector come in and examine the property. And kind of on that topic, so if you have your property listed for sale and you go under contract and a buyer has an inspection done and they come back to you with an inspection report that says you've got these issues, you've got mold, there's radon, whatever the case may be. Once the seller becomes aware of those types of issues, the seller should then be starting to disclose, and they need to update the seller's property disclosure about those issues. So that is the seller's property disclosure. Any questions about that one?
We do. Is there a mold disclosure document?
So the Real Estate Commission doesn't have a commission-approved mold disclosure document. I think a lot of the brokerages licensed in the state of Colorado have hired an attorney or have their own disclosure, but we don't have a commission-approved one.
And do you have any tips or ideas on what are some really common pitfalls to look out for when the seller fills out the SPD form?
So based on what the Forms Committee is working on right now, I've been hearing a lot of concerns that this is a challenging document for sellers to complete. Remember, you're completing it based on your current knowledge. You're not expected to complete, you're not supposed to be able to report back on like 3 owners ago. It's your current knowledge about the property. If you have questions, ask questions. You may need to seek legal advice depending on what some of the issues are, but definitely be as truthful as possible, because it is pretty regular that we get complaints in about sellers who have failed to disclose adverse material facts. And when it's the seller, the message that we communicate to the consumer is that they're going to need to contact a real estate attorney about that, because we don't have jurisdiction over the sellers.
And as a follow-up to that, a lot of people sometimes wonder, what is an adverse material fact?
Well, it's typically something that's a negative aspect about the property that could hinder your ability to use it. A lot of what we typically tell the real estate brokers as far as adverse material facts are concerned is that it's not up for the broker to decide what is or what is not important to the consumer. They should just disclose and then let the consumer decide whether it is of importance to them or not. Some people, are not concerned about radon levels in the soil or those types of issues, but ultimately it's for the consumer to make that decision. So it's really going to depend on what's important to the individual consumer, but if it negatively impacts the property, that would be considered an adverse material fact.
Okay. And I have a question here. What does it mean to sell the house as is?
Typically, when a seller says that they are selling the house as is, it means that they're not going to do any repairs to it. It's in the state that the property is in at the time that they have it listed for sale. It doesn't mean that when you go under contract that you can't ask for repairs to be done. I just wouldn't be surprised if I was that buyer to be told no, because they've advertised it as being as is.
Okay. We can now move on to the next section, and that's the contract to buy and sell.
So this is the daunting contract, because it is typically 19 pages long. We've got several different iterations of the contract to buy and sell. There's the residential, there's the income residential, there's land, there's commercial, there's the Foreclosure Protection Act, and then there's a manufactured home contract. We're just really going to focus on the residential one. That's pretty typical, the type of transaction that most people are going to deal with. So again, this is a legally binding contract. This is the contract that is between the seller and the buyer. And right at the top of the contract is pretty much an advisory about it being a legally binding contract, and putting everybody on notice that they should consult legal and tax or other counsel before signing this document. This document is used to memorialize the terms of your purchase acquisition of a property. And the real estate commission contracts are really focused on resales. If you're looking at new construction, you're typically going to be dealing with a builder. Builders have their own contracts. They're not We don't regulate the builders. And with a builder's contract, you may be represented by a real estate broker. This is a type of transaction, though, that you may end up needing to engage a real estate attorney in as well, because typically the builder's contracts are skewed totally for the benefit of the builder. So you need to be really careful with those types of transactions. I will say with the contract to buy and sell, as we go through this document, you're going to see a lot of outs given for the buyer. And it just kind of goes to the whole concept of buyer beware. So just starting off with the contract to buy and sell, one of the first things that you're going to have to figure out is how you're going to take title. And there's typically kind of 3 different options. There's inseveralty, that's me buying the property by myself. There's joint tenancy. An example of joint tenancy is my husband and I purchase a house, there's rights of survivorship, so if I die, the whole house goes to him. And then there's tenants in common, and that may be a situation where I purchase a property with a business partner. We do a 60-40 split. There's no rights of survivorship. Depending on how you're going to take title, this may be something that you want to consult with legal advice and also tax advice on. But that's one of the first questions out of the gate in that contract that you're going to have to deal with. Then you've got the legal description of the property. And like I said, with the listing contract, with the legal description of the property, you need to use the legal description that is on the vesting deed, which you can get a copy of that from the clerk and recorder's office. Best not to use the abbreviated description that you get off of the assessor's website. But if you're in a time crunch and that's what you have to use, then your broker is probably going to need to do an amend extend to update the actual legal description. Then you're going to deal with the inclusions and exclusions, and I address this kind of with the listing contract. So if I'm the seller and I'm taking grandma's prize roses with me after this property sells, that needs to be listed as an exclusion in this contract. Just like if on the buyer side, I want the seller to leave the refrigerator and their washers and dryer, then that's going to be listed as an inclusion. Then you get into earnest money deposit. The contract requires that the earnest money deposit be tendered with the contract unless the parties agree to an alternative earnest money deadline. And it's also kind of, when you have a multiple contract or multiple offer kind of situation, it's not uncommon that it's when the contract is actually executed that then you're dealing with the earnest money deposit. The important thing that you need to know, though, about the earnest money deposit is when we start going through the dates and deadlines, those aren't guidelines. Those are hard and fast deadlines. And if you're going to miss them, you could lose your earnest money. And depending on how much earnest money you put down, that can be a really painful lesson about missing a deadline. So the contract has a dates and deadlines grid. This is an easy reference for you to be able to look at the contract and say, okay, my title resolution deadline is X date. And when you look at this grid, there's reference numbers. So if you have a question about, well, what is my new loan terms deadline? What does that pertain to? Then you can look at section 5 of the contract, that specific paragraph, and that gives you the explanation of basically what those terms are. And then if you've got a date or a deadline that's left blank, you have NA for not applicable put in there, or it's deleted, then that deadline doesn't apply, and the corresponding section in the contract is also, it's deleted at that point too, or it doesn't apply. Now, I said earlier that there's a lot of outs for this. The contract to buy and sell does give the buyer a lot of opportunity to raise different issues about the property or the transaction, and to request either resolution of those issues or to terminate the contract. And I know that one of the questions that we got was, well, how can a seller terminate? Well, after you've basically kind of agreed to sell your property, you've agreed to sell it. it's going to be how you manage these different issues that come up with the buyer. So if the buyer, if I listed my property as a seller as is, and the buyer has a property inspection done, and then they come back with a list of 30 different items that they want me as the seller to fix, I can say no. And if they don't rescind that request that I fix them, they could terminate the contract, and that basically could kill the deal there. Otherwise, pretty much when you enter into a contract as a seller, you're going to be you're expected to consummate the transaction. The contract itself really isn't geared towards giving the seller out. It's more for the buyer. And I went into the deadlines about those being firm deadlines. Now, if you need to extend them, just like with the listing contract, we have documents that enable the real estate broker to extend those deadlines out. And you're going to see this a lot, particularly if you're getting a mortgage loan, because that seems to be one of the things that will cause a transaction to extend past that original closing date. So it's really important that you remain in contact with your lender to find out what the status of your loan is. And you need to communicate that status with your real estate broker, because if you're going to start missing those deadlines, your real estate broker needs to be trying to extend those out. With that said, though, your real estate broker can ask to have those deadlines extended out. The seller can refuse to extend them. So just keep that in mind as well. But you really need to keep an open line of communication with your real estate broker about what's going on with your loan or what may be going on with the appraisal, so that they can make sure that if they need to seek an extension, they can do their part to try to protect your earnest money. There's a couple of disclosure deadlines that are in this. One is the seller's property disclosure. So if you haven't stricken that language out, that means you're going to be providing that seller's property disclosure, and there's a deadline for that. There's also a paragraph regarding the methamphetamine disclosure, and this is required. You have to disclose that it was an illegal drug laboratory, specifically methamphetamine is what's named in the contract, if it hasn't been remediated. If the seller did have it remediated, the seller doesn't have to disclose that that was an issue. And the only reason that they don't have to disclose that is because of current Colorado law. There's also a disclosure regarding carbon monoxide alarms. So if the property has fuel-fired heaters or an appliance, a fireplace, or is an attached garage, the seller has to assure that there's an operational carbon monoxide detector within 15 feet of each bedroom. So those are some of the statutory disclosures that you need to be aware of, particularly if you're going to navigate one of these transactions on your own. Another thing that you need to be aware of once you go under contract is this is not a time to just sit back and relax. There's a lot of due diligence required on the consumer's part. Your broker is not responsible. They're going to keep you advised of the transaction, but you still have a lot of work that you have to do as well. So you're going to be arranging the property inspection. You're going to work with your lender about the appraisal, and your broker is going to play a role in that as well. Like I said, you need to be in constant communication with your lender about what's going on with your loan, because if they need additional loan documents in order for you to be finally approved and closed, you need to be making sure that you're getting those to your lender, but also talking to your real estate broker if they need to extend out deadlines. There's a lot of documents that you're going to have to review as part of your due diligence. So if the property is located in a common interest community or an HOA, you're going to have a lot of documents to review pertaining to that. You're going to get a title commitment. You need to review that to make sure that you don't have any issues about that. Your broker may flag some things, but they can't give you advice about a title commitment. That's going to require legal advice. So if you notice an issue, you're probably going to need to reach out to an attorney at that point. If there's an existing lease on the property, that's something that you're going to have to deal with. There's off-record title matters, and those involve liens typically. You're going to need to arrange for a survey or an improvement location certificate. Those are not one and the same and shouldn't be confused as being the same. And the important thing to know is it costs money to purchase a property, not just the ultimate sales price, but you're going to have to pay for an inspection, an appraisal, a survey, and those are costs that the consumer bears. Those aren't the responsibility of the real estate broker. Some brokers may agree to pay certain things, but typically that doesn't happen, and those are going to be costs that you have to bear as a consumer. Then part of the contract to buy and sell has to deal with the closing provisions. Closings are typically handled by a title company, although we do still have some real estate brokers in the state that will handle their own closings. But there's a portion that discuss who's going to pay the closing costs. Is it going to be borne by the seller, by the buyer, split in half? It discusses transfer of title, what type of title will be conveyed. And then it also addresses the different types of fees associated with closing. Depending on what part of the state you're buying in, there may be transfer fees, there may be special taxes, and that's all addressed in the contract to buy and sell. There's also provisions in the contract to buy and sell to address what happens when either the buyer or the seller defaults, your termination rights and the effect. If you have to go to mediation, that's to address disputes that arise relating to the contract, and it spells that out for you. With earnest money disputes, and we get a lot of complaints about earnest money disputes, and for the most part, the Real Estate Commission has no jurisdiction over an earnest money dispute. So if I was a buyer and I did not adhere to the deadlines, and then the seller decides, well, I think you defaulted on the contract and I'm going to keep your earnest money and this isn't closing, you can't file a complaint with us because the seller won't release your earnest money. That's not how it works. You've got a couple of different options available to you. You can have a legal proceeding between the buyer and the seller. The earnest money holder can interplead all the parties and deposit the earnest money into a court of competent jurisdiction and let the court deal with it. And then also the earnest money holder can notify the buyer and seller that unless they receive some sort of notification, such as a copy of the summons and complaint or a claim containing the case number for the lawsuit within 120 days, that the earnest money holder is going to return the deposit to the buyer. And in most cases, the earnest money holder is probably going to be a title company. And then the last part of the contract to buy and sell is the additional provisions. And these are additional terms that are not typically covered in the rest of the template language of the contract to buy and sell. And what you will typically see kind of in this area is if the buyer and seller have negotiated that there's going to be seller concessions paid to the buyer, they'll be spelled out here. If there's a contingency, if you have to sell a house in order to buy the house that this contract is for, then the contingency needs to be put in the contract. We've been getting a lot of complaints about real estate brokers who are missing contingencies. And so I think that also speaks to you as a consumer. If you know that you have to have a contingency when you're going through this contract with your real estate broker, you need to keep an eye out for those types of terms that are important to you, and flag them for the broker that, hey, you're missing the contingency here, or, back in exclusions, you miss grandma's rose bushes. You need to be reading this document as well and keeping an eye out for all of those things that are important to you too. What we'll also see, particularly in the current market that we have, is you'll see clauses in additional provisions. One may be an escalation clause. So if you've got a market where you've got a shortage of inventory and there's a lot of bidding wars, escalation clauses may be the way that you're able to win that ultimate contract. Those are typically clauses that are drafted by an attorney. You need to make sure that you understand the clause. The broker needs to make sure that they understand the clause, because you could end up paying a lot more for that property due to an escalation clause than the list price. Also, what we see are appraisal gap clauses, and that's where you agree to purchase a property. basically the appraisal comes in for lower than the purchase price, that gap clause is typically saying that you will pay the difference. You need to understand those clauses as well too, because when the market settles down, you may find out later on down the road when you go to refinance or sell the property that you paid a lot more right now than it may be worth here in 5 years. And if it's due to an appraisal gap clause or an escalation clause, some of that you took into consideration and you agreed to. So those are the types of things that will be covered in additional provisions. Typically, any language that is of benefit to a real estate broker representing you in a transaction does not belong in additional provisions. There is an exception. And when I talk to you guys about real estate commissions and payments, so if I was a buyer and I was looking at a property and the cooperating commission that they were willing to pay my broker was only $1,000, but say like I had agreed to pay my broker a commission for $5,000 and I am on the hook for making up that difference. If I direct my broker to put in language in the additional provisions seeking the difference in those commissions, that would be acceptable because me as a principal has directed my broker to do that and it's to my benefit. So that is about the only time you're allowed to have something in the additional provisions of the contract that relates to broker commissions. And that's strictly because it is directed by the principal of the transaction. The broker on their own cannot put that language in there because this is a contract between the seller and the buyer. It is not a contract with the broker at that point. And just before we go into the questions, some other things to be aware of when you're dealing with contracts. So the real estate brokers have a limited license to practice law in Colorado, and what that means, and that's by virtue of having a real estate broker's license. So they're allowed to complete contract documents, and they're the commission approved ones. There's other forms that they can use. They can't draft their own contracts. An attorney's license is required for that, but they can't give you legal advice. So if I was going to ask my broker, hey, what's the best way for me to take title? Should we take title as joint tenancy or tenancy in common? That is a question that you should be or a conversation that you should be having with an attorney or maybe a tax advisor, depending on what the implications are. The other big thing that we see and hear about when we get consumer complaints in and also inquiries is consumers don't read the contracts. It is imperative that you read these documents. They're legally binding contracts. Typically, these are the largest transactions people are ever going to be involved in. They're high stakes. You need to be very aware of what you are committing to, and if you have questions, you need to ask them. And if it's a question that your broker can't answer, then you need to probably consult with an attorney at that point. It's better to be very well informed before you end up with a property that has a whole bunch of issues rather than trying to deal with those whole bunch of issues after you've closed on it. So Gary, shall we go to questions?
Yes, Director Waters, you talked about additional provisions, and one question is, are there additional provisions that must be prepared by an attorney as opposed to a real estate broker, buyer, or seller?
So those types of clauses that I brought up, escalation clause and appraisal gap clauses, those should be prepared by an attorney.
Okay.
The basic sentence of the seller is going to give the buyer $5,000 for a carpet allowance, that wouldn't have to be drafted by an attorney.
Okay. And how do I know if my earnest money is protected?
Well, so if it's being held by a real estate broker, we have trust account requirements. The Real Estate Commission has accounting requirements that protect your funds. We require that the broker place those in trust accounts or escrow accounts. I believe there's some protections on the title side. They are regulated by the Division of Insurance, but those are pretty much the protections available to you.
Okay. Now, the buy-sell contract that you went over seems to put greater obligations on the seller. Is there a reason for this in the first place?
Well, it's supposed to be, I know that over the years, the forms committee has tried to make this form as fair as possible, but you also have buyer beware. So that's why there's a bunch of outs for the buyer. But some of it stems from also just who the responsibility rests with. If you're purchasing a property that's in an HOA, it's the seller's responsibility to produce those documents. They're the ones selling the house. So the HOA is not responsible for providing the documents. Just like the title commitment, that speaks to, that's kind of backwards viewing as far as insurance is concerned, or when you get the title insurance. So, I mean, it speaks to kind of if there's been any encumbrances while the seller's had it, comes into play. So I don't know that there's a lot of obligations necessarily placed on one or the other. I'm sure if you're the buyer in a transaction, it feels like you have a lot of duties to fulfill as well.
Okay. And we talked earlier about, negotiating a commission for the broker in the listing contract, but can a broker negotiate their commission on the contract to buy and sell?
No, absent that one exception that I described, where it's driven by a principal, the broker is not allowed to negotiate their commission within the contract to buy and sell.
Then I have kind of a specific question. If the buyer is represented only by an attorney that is not a licensed broker, is the attorney entitled or allowed to receive payment from the brokerage firm's success fee?
So commissions, based on our license law, commissions can only be paid to a real estate broker. I don't know about the Practice Act for attorneys. I would assume that there is a different compensation agreement, such as a retainer fee and an hourly rate. So for an attorney who's not licensed as a broker to seek the payment of a commission, that would probably cause an issue with the real estate commission as far as unlicensed practice is concerned. But I think they would also have to evaluate kind of what else the real estate attorney was doing.
Okay. And I wanted to remind everyone, all of the forms that Director Waters went over are located on our division website, so everyone can view those. I have no other questions, Director Waters. If there's anything you'd like to say in closing, we like to direct consumers and licensees to our website. We have information on consumer resources and HOA information, and we have a follow-up email also. Anything in closing, Director Waters?
Nope, just thank you for attending the webinar.
Well, thank you for another great presentation. And everyone, this presentation has been recorded, so if you missed something or you want to go back, we will put it up on YouTube and have that link sent out to you. So we want to thank you all for attending and have a wonderful rest of your day.